watching the Florida Channel, a public service of the Florida Legislature, WFSU-TV, and Florida State University.
Ladies and gentlemen, the Florida Supreme Court. Please be seated.
Good morning and welcome to this session of the Florida Supreme Court. The first case on the court's calendar this morning is Lewis versus Leon County. Are the parties ready to proceed?
We are, Your Honor. May it please the court, Lewis Hubiner with the Office of the Attorney General representing the appellants in this matter.
And please speak into the mic, keep your voice up.
Thank you. 2 years ago in Christ versus Florida Association of Criminal Defense Lawyers, this court held that the newly created public offices of criminal conflict and civil regional counsel were not public defenders under Article 5, Section 18A of the Florida Constitution. This case presents the question whether the Public Regional Conflict Counsel are court-appointed counsel within the meaning of Article 5, Section 14.
Well, let's look back, though, on the particular history with respect to the conflict counsel. At the time that Article 5 was, Section 14 was adopted, conflict counsel was the cost of paying for conflict counsel was an obligation of the state or the county?
It was largely the counties.
And then was it very clear that when the when Article 5, Section 14 went into effect, that the cost of conflict counsel was to be borne by the state?
Of the conflict counsel as they existed at that time, because they were private counsel, and their fees were set by law. So,
but what I guess what I'm getting at is that the state had to take on this obligation of conflict counsel, and they then made a decision after having the private conflict counsel system that it would be a cost savings for the state to go to a system of regional counsel. And so that cost savings was certainly a savings to the state, but I'm trying to understand under what logic there would be then to say, well, but we're going to now, even though we're saving all this money, we're going to now shift a cost that was never contemplated at the time of Article 5, Section 14, back to the counties.
Well, because I think the distinction is clear in the constitutional language, and that is all of the public offices that were part of the judicial system were entitled to a certain amount of public funding from the council for their overhead cost.
But that is what the language actually says. The language is very specific and actually delineates those offices that are supposed to be paid by the state and those offices and those items that are supposed to be paid by the county, isn't it? And when it comes to the county, does it say anything about court-appointed attorneys?
It does not say anything about court-appointed counsel, but you have to ask the reason for that. I think what you have to do is take the approach that the 4th District Court of Appeal took in the recent case it decided of Fort Lauderdale versus Crowder, in which it construed the same constitutional provision and said you have to consider what is the object or purpose of the constitutional language, what was the prior state of the law. And in construing that language, it held that this same provision did not preclude the legislature from requiring public defenders, from requiring counties to pay public defenders for defending persons who violated municipal ordinances. So you cannot take an absolutely literal approach to this. You have to look at what was done at the time. And if you consider that, you find that the distinction here for funding is between public offices and private and court-appointed counsel who were all private, whose fees were paid by the county, and who had no need of being paid these various itemized overhead costs. But that does not indicate an intent to forever preclude the legislature from requiring counties to fund the same costs for a public office that did not exist then but was subsequently created.
Are we reading something and saying that this is what the people would have voted for had it been, but that's not what the people voted for as I see it. The people voted for funding of court-appointed counsel to be done by the state. And if we want to change that, shouldn't there be a constitutional amendment to change that? I
would beg to differ with you for this reason. That is, if anyone going to the statutes, which was where you would have to go to find out who these court-appointed counsel were and what they did, would find that they were private.
Well, but what about if you went to the Constitution and looked for the definition of public defenders? Wouldn't you find something there that is different than the definition that has been now established by the legislature? And isn't that a problem for your argument?
The legislature...
I think you've made a very creative argument, but I think that one of the impediments you have there is that very clear definition in the Constitution, which I think we would have to assume that the voters were aware of when they were employing the term public defender in the context of this amendment.
I'm not quite sure I follow that, because maybe you can clarify for me, but you said that public defender is defined differently in the law than in the Constitution?
I'm not talking about anywhere else in the law, but basically I think if I understand what's going on here, the legislature has included this new office within the definition of public defender, whereas that is not something that is contemplated in the definition of public defender that's in the Constitution.
Okay, I follow you, but I think the court distinguished that in the Chris case, where it said those definitions were purely for purposes of funding. That's all. It does not, as the counties argue, enlarge the definition of public defenders. I think that you can give that a constitutional construction just by saying that the regional conflict counsel are entitled to the same funding as these other entities.
But the point is when the people in a constitutional amendment use the term public defenders, wouldn't it be most reasonable and overwhelmingly reasonable to assume that they mean the public defenders that are defined in the Constitution?
Well, I think we're getting...
I understand it's inconsistent with your argument.
The distinction or the definitional problem exists in the statute, not in the Constitution. The constitutional language only refers...
I agree that we are not here to decide whether there's a problem in the Constitution. I agree with that. We're decide whether this statute is consistent with the Constitution.
Exactly.
Well, I'm waiting. Please answer, Justice Kennedy. I was just going to ask you follow up on something you just said, but please answer his question.
Well, again, the constitutional language distinguishes between public offices and court-appointed counsel. A person who was voting in 1998 would have understood court-appointed counsel to be private counsel who had no need of these overhead costs being paid by the counties.
I guess that's where we get back to your creative argument, because what I guess what I'm still having trouble understanding is that by specifying 5 or 4 different categories of offices, including public defenders, they necessarily excluded anything else. Like, for example, the office of capital collateral representative is not was existing back then, and it was not. I think it was, or nobody is, and I don't think the states ever argued that the counties have that responsibility.
I think you're relying on the.
CCR, is that a state or a county responsibility for their offices, for the cost of their?
Well, they are. Most of them, I think, are paying for them. They're not being provided by the counties at this point, but under this 2007 Act, the counties are supposed to pay for the facilities of all these entities.
She's asking about capital collateral. Capital collateral offices are totally funded by the state, aren't they?
Right.
Including overhead.
Is that correct?
As far as I know, that's
so
correct.
It sort of cuts against your argument that the intent was that for any state entity, that the county would pay the cost of the facilities. And it goes back to this idea that the whole intent of Article 5, Section 14 was to shift the overwhelming majority of the state court system and its associated entities to the state other than specifically defined categories. And for you now to say that Public Defender's Office, which is specifically stated, which is a clearly defined and was defined in 1998, was to include anybody that was conflict counsel is just I'm not following that.
I'm not making that argument. My argument is that the court-appointed counsel in 1997, 1998 were private counsel. They have been replaced by a public office. Those previous private conflict counsel actually still exist, and they are the second-tier conflict counsel.
But I guess what I'm going back to, your argument is that we should rewrite this provision in the Constitution that gives specific types of offices, public defender's offices, state attorney's offices, and the offices of the clerk, and write into that the intent was that the county would fund any office that was a state-created entity.
Well,
I mean, that's the argument.
That's not quite how I have argued it in the brief, or would argue it here.
Well, I know it is, but isn't that defined? I mean, if we cut through it all, that's, you're saying it's not, you're saying it's not fair because this is really more akin to a public defender office for funding purposes than it is to private conflict counsel.
Well, I think you're basically relying on that expression, expressio unius est exclusio.
That's why I wouldn't say it, because I could never say that one.
I practiced it. And that is ordinarily a maximum of statutory interpretation, not constitutional. And it has not often been applied to the Constitution because it cuts against the theory, and that is that the legislature's lawmaking power is plenary unless it is clearly restrained by some constitutional provision. In this provision, you have a list of public offices that were entitled to county funding. You now have a new one that did not exist in 1998. So the question is, under our theory of the Constitution, is does it clearly preclude the legislature from adding to that list?
It wouldn't if you...
The reason I'm smiling is because you act as if this is some right of the Office of Regional Counsel when they're going to get funded, whether it's by the state or the county. We're not looking at the constitutional right of the Office of Regional Counsel. We're just trying to decide whether the voters intended for that cost of an office that is not the public defender's office to be borne by the county or the state.
Well,
so, I mean, is it?
I think I would phrase it differently. I would say what the voters intended was that they would fund all the public offices that were part of the judicial system, and private counsel would not be funded.
You'd have a much better argument if there was some language in this constitutional provision that said, other offices that are court-related. But, in fact, they didn't. And I still go back to the CCRC provision, and they were, in effect, at the time that this constitutional provision was passed and when it was implemented, yet they are not funded. Their overhead is not funded by the county. And I don't see a real difference between these regional conflict counsel offices and those offices.
Well, I don't know that the legislature might not consider that differently if it were to make that decision, that perhaps the CCR offices could benefit from some support from the counties.
You see, it seems to me that what we're allowing to happen, even if they wanted to do something like that, is we are allowing them to amend this constitutional provision without going to the voters and asking the voters, look, things have changed here. Let's amend this constitutional provision and provide that all of these public offices that are court-related have their communications and buildings and all of that funded by the county.
Well, because these offices, this office of Regional Conflict Counsel did not exist in 1998, my argument is that the voters did not intend to preclude the legislature from funding an additional public office.
But just think about this again. I guess I start with my common sense argument that, approach to this, which is that the state, in creating these offices, was intending for there to be a cost savings to the state. Now they want not only all these millions of dollars of cost savings to the state, but then now they want to shift additional costs back to the counties. And the counties have every reason. That's who whether there's a constitutional violation for the counties, but the counties they can't raise additional revenues. So we're taking the state and saying they can shift costs that were state costs back to the counties who don't have the ability to raise the revenue.
Well, they're already funding these other offices and the itemized expenses. I don't know that...
So there's no cost associated?
Well, there is a cost associated with it, but I don't know that it's overwhelming or impossible.
Do these regional councils have an office in every county?
I don't think they do in every county, no.
Well, how does that work?
They certainly
work? Because how does that work with the counties then? If like in a particular circuit...
Well, they try to negotiate... they have tried to negotiate space where they think it's most needed.
With only the county where that is actually located pay for it, or with the other counties?
If they will do it, they have probably made overtures to all the counties in their
chip
in their district. Yeah.
Is that set out in the statute? How that? Be?
No, it's not. I don't believe it is. I'm well into my overtime. There is another issue that I just would like to allude to briefly, and that is whether the inclusion of the funding provision complies with Article 7, Section 18A, which requires that the legislature determine that the law fulfills an important state interest.
Is there a specific language in the statute that complies with that article about the unfunded mandates?
Oh, I think there is in sections 4 and 31 where it says the law fulfills constitutional mandates for providing counsel to the indigent, that it provides for legal representation where required by general law, and as a
And it
necessary
certainly says that the state believes that this is good for them because it's going to save them money, but...
No. It goes far beyond that. It alludes to the constitutional mandates that it's fulfilling. It says that it's providing legal representation where, in addition, it may be required by general law. I think that's a clear statement of public importance. The disagreement is not with whether this act actually serves an important public purpose. It's whether the legislature used magic words to say that. And it did not, but I would submit that it said everything but those magic words. And in the end, to determine whether a law serves an important state interest under this provision, you have to look at the law, not magic words. And I think the law clearly reflects a legislative finding of public importance.
All right.
Thank you.
You have about a minute left for your rebuttal.
May it please the Court, Ed Dion from Neighbors, Giblin and Nickerson. We are privileged to represent 25 counties in the Florida Association of Counties in this matter. And Justice Kennedy, at least our 26 counties, including Volusia, have in fact been requested to pay for offices and other those overhead expenses, if you will, that you previously requested.
So if the regional council offices are in every district, like the district courts of appeal.
That's correct.
And so if, for example, in the second district area, all of those 14 counties have been asked to chip in to pay for the regional council office?
Chief Justice, I'm not sure that all of them have. In some of the smaller counties, they may not have those offices, but I believe in the vast majority of the counties in the state of Florida, the Regional Conflict Council has established an office and has employees to represent those persons as they're required to do under the statute. But I'm not sure that it's 100%. I think this Court has already hit on the fact that clearly under Article 5, Section 14, the state is responsible for paying all of the costs associated with the state court system, except for those overhead costs that we've been referring to that are set forth in subsection 15, or subsection C, I apologize. And those are only for the trial courts, public defenders' offices, state attorneys' offices, and the offices of the clerks. Those are all constitutional offices. They're not just public offices, as the state has alluded to. They're constitutional offices.
Well, I was thinking it's also the district courts of appeal, of course, are not in there because that's always been a state-funded mandate, and
that's part of the state court system, as are the trial courts, as is this court. You are 100% funded, not by the counties, but by the state of Florida.
Well, we're not 100% funded.
Well,
Never that.
but the counties do not pay for any of the expenses involved in this court's operations. So we know that the state, under Article 5, Section 14, that the state of Florida has to wholly fund court-appointed counsel, now known as the OCCCRC, Regional Conflict Council, I call them Regional Conflict Council, or whatever else you want to call them, and whether they're public or private. Contrary to the appellant's argument in this case, the Constitution makes no distinction between public and private and makes no reference to any overhead costs. All of the costs associated with court-appointed counsel have to be paid for by the state of Florida. In addition to that clear language of the Constitution, we also are fortunate to have the intent of the framers of that provision, which clearly stated that it was their intent that the state be primarily responsible for funding the state court system and wholly responsible for funding court-appointed counsel and related costs.
Is it really the intent of somebody on the commission or whoever the framers were, is that really the intent we need to look at, or should we be looking at what we would understand to be the intent or the understanding of the voters who adopted the amendment?
I believe it's both, Justice Kennedy.
What if they're different?
Well, But the one thing that you have in this instance...
Does this inform our judgment about what the people would have thought about it?
This certainly should, because we have no writings from the public. We have this statement of intent by the framers of these provisions that clearly set forth what it was that they wanted to... But
don't we really, in terms of looking at constitutional construction, which is similar to statutory construction, we look at the plain language, and there's any way you slice it, public defenders' offices are different from conflict counsel offices.
And you specifically found that, Justice Pariente, in the Chris decision, where you specifically said that they're not public defenders. So it's illogical to say that they're not public defenders under Article 5, Section 18, but for some reason they are public defenders under that same Article 5, but Section 14.
Yeah, I think in the opinion, I haven't looked at it recently, we knew this controversy was brewing, so we didn't address it because it wasn't before us.
Correct.
And that's correct, right? There's some reference to that in the opinion that we were not going to address that.
You never actually get to Article 5, Section 15, because I believe it was never raised. That was a quo warranto case that came before you, and it was clearly only brought on the basis of Article 5, Section 18, the definition of public defender. So that wasn't here before. Actually, Justice, we believe that was almost an invitation for the counties to challenge this funding provision because it wasn't addressed in that case. And you also found out that other than the fact that they are now government offices and the private registry counsel are independent contractors, their responsibilities are identical. And the whole point of the Chris case was it's not what you call them, it's what they do. And what these people do under Section 2740 is they're clearly court-appointed counsel as intended by the framers and by the people who adopted Article 5, Section 4.
But, there could be an argument that a voter, really, public defender's offices are, it's paying for the cost of defense of indigent, and that they really would not know the difference between whether someone has to representing an indigent on a conflict or not. So, if we really look at and say it's the voter's intent, as opposed to saying public defender's offices have a clear meaning, and and we don't go farther than that. Then you wouldn't even look at the statement of intent, I guess, is my point.
We agree with that. We believe the clear language of the Constitution provides that the counties do not have to provide any funding for these court-appointed counsel, irrespective of what they're called, irrespective of where they sit, and irrespective of how many counties they're in. They're clearly court-appointed counsel. The Constitution requires the state of Florida to 100% fund those.
What about the state's argument that that the legislature has broad authority and it's sort of their prerogative to pass laws that unless they're clearly unconstitutional, we have to defer to the legislature? How does that work in the context of this constitutional provision?
Article 5, Section 14 provides the exclusive method for funding the components of the state court system. And therefore, because that is the exclusive method, the legislature has no authority to go over and above that. They have to conform with the provisions of Article 5, Section 14, which is clearly what they haven't done in this instance. But what they tried to do is, in order to overcome that limitation, they changed the definition of public defender in order to try and include these court-appointed counsel into that definition in order to require the counties to do that. And we've argued in our brief and below that that's improper for two reasons. Number one is they have no authority to expand the definition of public defender, and I think we've discussed that a little bit earlier. Article 5, Section 18 is very clear. The legislature had no authority to change the constitutional definition by statute.
And isn't that truly the basis of the Chris decision? The reason we said these offices were okay was because they did not violate that definition of what a public defender's office is.
Yes, Chief Justice, that's exactly what the state argued in the Chris case is. They have to be okay because they're not public defenders, and now they're coming in here and saying it's okay to call them public defenders. That just doesn't wash. You can't have it both ways in this instance. So because it's clear that express or implied provisions of the Constitution cannot be altered, contracted, or enlarged by legislative enactments, their attempt to include regional conflict counsel in the definition of public defender likewise fails. If I may, I'd like to go to Article 7, Section 18. We believe that this law clearly violates that provision as well.
Well, I mean, their argument really is that when you read those sections, I believe it's 31 and 4, that it really does set out a state, that this is a state interest, which is basically a great state interest, which is basically the language that you're supposed to use, and that language complies with that. And what's wrong with that? Because it does seem to me it sets out why we need these offices and the public good for these offices, all of that.
Chief Justice, Article 7, Section 18A requires that the legislature must determine that a bill, a general law that imposes a mandate upon the counties, fulfill an important state interest. That's the language that's used by the
Is there a decision in which we have said you absolutely must use those words, otherwise this provision is not satisfying?
Justice Lewis, I'm unaware of any cases where this court has specifically done that. However, the legislature has done that previously, as we've provided an example before.
Well, are you saying that without question that unless those words appear, that the legislative provision must be stricken?
No, I'm not.
Okay. And so how is this one different? I think Justice Quince is hitting right on the essence of the issue, is that, I mean, if you say it in so many words, you know, if you don't have an absolute requirement, where does this one fail?
Well, what the provisions provide, Justice Lewis, are that they found that the creation of these counsel are necessary and the best steps toward enhancing the publicly funded provision of legal representation in a fiscally responsible and effective manner. I don't believe that states that this act fulfills an important state purpose. But even more importantly,
are you saying that because we in the system understand it to a different level, that the lay person does not? I mean, because when you say those words, it seems to me, to a group of folks that are here this morning, that's a pretty good statement as to this is a great need for the state.
Well,
do you disagree with that?
I think more importantly than that, if I may, is that the provision says that they must determine that it fulfill an important state interest. Part of our argument is that they didn't even determine that. And it's clear from the staff analyses.
Well, how do you determine that? I mean, I'm not sure what more, without using those specific words, that the legislature could have done to say that this is an important state interest.
Chief Justice, what they did, what the legislative bodies did, is once Article 7, Section 18 was developed, they created a process whereby whenever a bill may become an unfunded mandate, that they have a sole provision in the staff analyses which addresses that. Clearly, in this case, they didn't address that. It's not a constitutional requirement, but it's a legislative requirement. All it goes to is to show you that the legislature never considered whether this was an unfunded mandate or not.
But didn't they? Well, there's a part of the legislative analysis that talks about they were appropriating money for the beginning of the setup of the regional counsel's office, correct? And then they said in later years this was going to be borne by the county, or some language to that effect. So it seems to me that at least there was some consideration given to the fact that this was going to be county funded after that initial point.
I would refer you to the professional staff analysis and economic impact statement for PCS Senate Bill 1088, Article 4, which are constitutional issues, which is what they go through whenever there's the potential of an unfunded mandate. And it specifically says municipality, county mandates, restrictions, none. Since they don't have any language in the bill that says anything that we've made this determination, and there's nothing in their staff analyses that would lead us to believe that anybody in the legislature actually considered it, there's no way they could have specifically determined that this bill fulfills an important state interest.
Is the purpose of that constitutional provision not just to say that we've said it's an important state interest, but as you say, it's the unfunded mandates section. So the legislature isn't supposed to be passing bills that pass costs on to the counties without providing a means for the counties to pay for it. So what I'm more interested in now is what the statement is, but what's the purpose of this provision to begin with? Aren't they supposed to see if there is a way to fund whatever it is that they're passing on to the counties, short of just saying you've got to pay for it? Isn't that part of the intent of the constitutional provision, or not?
I believe the intent of the constitutional provision is just to get the legislature to take a step back and consider whether this is an unfunded mandate.
Well, but isn't that obvious? And just from the text of the statute, it's their county funding of court-related functions, and then they add something that has to be funded that wasn't previously there. That's right there.
But
I don't know how anybody could miss that.
But that doesn't mean that they actually sat there and said, you know what?
They looked at what they passed.
You know, I'm not going to argue that.
That would be true even if they had the magic words in there, right?
The fact is that the Constitution requires that the legislature take an act, and that act is to determine that such a bill, a general law, fulfills an important state interest.
Well, it seems to me this goes full circle to the idea that in this, even if they use the magic words, the fact is this was a mandate to the state to pay for conflict counsel, and they came up with a very good way from the legislature's point of view to save a lot of money for the state of Florida. And then they said, well, we can even save more by passing the costs on. So, I mean, that's where I think we go back to probably the first argument is probably the stronger one.
I absolutely agree. And please let me be clear that even if they had complied with the provisions of Article 7, Section 18, this bill would still be unconstitutional on the basis of Article 5, Section 14.
And with that, you are into your co-counsel's time.
Thank you, Chief Justice.
Okay.
May it please the Court, my name is Daniel Leckert. I'm the County Attorney for the County of Volusia, and I would pick up where the Court left off in questioning. Volusia's position today and throughout this case has been that Article 7, Section 18 does not matter, that Article 5, Section 14 exclusively governs, that the constitutionality of this statute is measured according to its terms. We believe that the statute clearly is unconstitutional, but the Article 7, Section 18 discussion is beside the point. Judicial funding is undoubtedly an important state interest. If that finding can easily be made, whether the Court requires it in a particular form. If the Court were to say that you could proceed under Article 7, Section 18, the legislature would have just only the requirement to pass it by requisite majority. That construction of the Constitution would entirely undo Article 5, Section 14, which was written later and is more specific and says that it exclusively governs. The framers knew in 1998 what Article 7, Section 18 provided. They said this section exclusively governs. And that is the test here. I don't think the language could be any more clear. Except as otherwise provided, subsection A says, except as otherwise provided in subsection C. And then subsection C says, no county or municipality except as provided in the subsection. shall be required to provide any funding for court-appointed counsel. From the Volusia's point of view, the court's decision should say that Article 5, Section 14 exclusively governs. We would ask you to affirm the decision of the First District, but clarify that Article Section 18 has no application here.
Well, let me ask you about that. I mean, the counties certainly are sensitive to the legislature passing unfunded mandates. So I have, and I don't know, I mean, we wouldn't need to get to it, but I'm still having trouble with the whole notion that all the legislature has to do to comply with Article 5, Section 18 is simply say it's an important state interest, and then it can be shifted to the counties.
Well, they could pass it by a requisite majority, is my understanding of the terms there. In fact, I think this statute was passed by unanimous or virtually unanimous legislature.
Well, you're always, I mean, if you have a battle between the counties and the state has an interest in passing as much on. I mean, it's the citizens. I mean, we're all going to end up paying. It's not a state entity, but so wouldn't it be better, I guess, to give Article 5, Section 18 some teeth to it as to what the legislature has to really contemplate before they're going to shift funding onto the counties or municipalities?
Well, the court may choose to do that, but I'm saying and there are certain subjects which they can pass on to us. For example, elections are county responsibility under Article 7, Section 18. They don't have to make specific findings. The Constitution does it essentially for them.
Well, let me ask you a quick question about, is there a regional counsel office actually in Volusia County?
Yes, ma'am.
And who is, are all the counties in that, I guess that's the 5th District Court of Appeal area, are all the counties in that area paying for these expenses?
Chief Justice, my understanding is that there's a office in most every county in the 5th District. Certainly there is in Volusia, which is largely consists of medium-sized counties. The office in Daytona Beach, in our case, services Volusia County. It's very close to the 5th District Court of Appeal, as a matter of fact, but it's not like the public defender's office.
There are other counties in that area. Is St. Johns County in that area, or Putnam County in the same DCA area as Volusia County?
My recollection is that St. Johns is
part of the.
Well, I think St. John's is in the 5th, and Putnam's in the 5th. But the Seminole, for example, Seminole is where the Regional Conflict Counsel for our district maintains his office. It's our neighboring county to the southwest. So you're talking about an office, essentially a smaller, an office of about 7 or so lawyers.
So it may be that there's one, in each district there's one main office, but then they maintain smaller offices. I think what Justice Kennedy's original question was just to see that this is even something that may be unequally borne by certain counties, depending on where the main office is for each district.
It may be. I think they try to staff according to the caseload, and they have an office, in our case, in Volusia County.
We thank you very much.
Thank you, Your Honor.
I believe you have a minute or so, Mr. Hubiner, for rebuttal.
Thank you. Just one or 2 points. I don't think the Chris decision really has much effect here, because there, at least as far as the inclusion of the Regional Conflict Counsel and the definition of public defenders, you recognize that was a funding provision, and there was a distinction between funding and function.
Who pays for the Attorney General's offices around the state?
As far as I know, that's all state money.
I mean, so this idea, I guess, and go back to your premise that if it's a state office but it's in counties, the counties were intending to pay for it, just doesn't seem like it holds any. It's not consistent in terms of how it's actually applied.
I have to differ, because I think the only entity that did not get this county funding were private counsel, and that was the
the
distinction that the voter would have understood.
Attorney General, District Courts of Appeal, we're not CCRC. We're all not funded by the counties.
Well, that's true, but that does not mean that the legislature couldn't add this one office to it in the absence of some clear prohibition. Thank you.
All right. Thank you both for your arguments here today. We really appreciate your help with this case. The next case on the court's agenda is Johnson versus State and Joyner versus State. We'll just give them a minute to clear the courtroom.
Yes, Your Honor. Good morning, and may it please the Court. Shannon McKenna, Assistant Public Defender on behalf of Mrs. Johnson and Joyner. The State failed to prove that a knowing, intentional, and voluntary waiver of credit for time served was clearly shown on the face of the record.
Could we go right to the heart of what I
Yes.
think really this is about? Because many times, many of these cases turn into play on words, and we're dealing with people's lives.
Yes.
And this may give us today an unusual opportunity, actually. As I understand it, in both of these cases, the individuals involved are no longer incarcerated, and so you've even argued that it's moot. And it may be. Yet we have competent counsel before us that could help us resolve what appears to me to be a problem. And it
Yes.
comes up from time to time, and as I look at this, we ought to be able to decide it on common sense and approach. And we appear to be on the horns of a dilemma a little bit. And it happens in the law. We have competing values. I mean, it happens a lot. But here, I'm concerned, I'd like both of you to address this. I'm concerned as to how an individual can be considered under the law as a matter of law of giving up something if they don't know what it is they're giving up. And by that I mean to know what they're entitled to. The boot camp case is one. I don't know whether this is the boot camp or not. But we can't expect each one of these individuals to know precisely what they have. Yet on the other hand, I'm concerned about the practical problems that our trial judges and defense counsel and assistant state attorneys face, and that is, how do you know when you're standing there in the courtroom exactly what it is? I mean, it'd be wonderful if everything was hooked into our JIS system, punch a button, and it tells you. So I'd like for both of you to address that dilemma that we face, because it's got to be a workable system so that every one of these doesn't have to be, take it through the appellate courts again. But at the same time, it seems to me that just all of us must agree that how can you give something up if you don't know what it is that you're supposed to be giving up? So with that, that's kind of a speech maybe, but I mean, to me it gets to the heart of what our problem is this morning that we keep seeing over and over.
Yes, Your Honor. What we would propose is that this court should find that the trial courts must ensure that there's an understanding of the waiver of credit for time served, and that would require three things. One, that the defendant have a knowledge that he's served prior credit for time served. Two, that they're entitled to this credit for time served. And three, a voluntary relinquishment of this right. As this court has pointed out before, in 1999, they actually asked the Criminal Appeals Reform Committee to look at the issue of credit for time served, and they've noted that in various counties it's handled differently. Jail logs are kept in some files, they're not kept in other files. defendants may have time from other counties or not.
So let's start with let's just start with the first item. You said there are three things.
Yes.
Okay, and so knowledge. How do you contemplate the knowledge aspect of it? Is a trial judge supposed to say, look, you were in one of these cases, it was a boot camp. You were in this boot camp for 3 years. You understand that by saying that you're going to only get credit from this point, that you no longer are entitled to the credit for the boot camp. Is that going to be a trial court's problem? The defense attorney, how would you do the knowledge aspect?
Ideally, it should be in the plea colloquy, as the court in the plea colloquy, as the trial court addresses other issues. The trial court could state to the defendant, do you understand you're only receiving credit for time served from your last arrest? You're entitled to any other credit for time served that you've received, when you were initially arrested or if you were in jail for whatever periods of time, and that you're waiving that.
Would it also require that there be a specification of the exact number of days?
I think that as long as they're aware that there was previous credit for time served and a general period, like that when you were initially sentenced, you were initially sentenced to a period of 364 days in county jail and then probation for 3 years. Now, we don't know if they actually served.
Wouldn't the time certain work better if you have 120 days? I mean, do it exactly, because otherwise somebody's going to misstate the time, then it's going to come up again anyway. So it seems to me
ideally, it would be, in a perfect world, it would be best to know exactly how many days they've served and exactly how many days they've waived.
But it's not a perfect world, and that's what Justice Lewis was talking about. My concern is that this is coming up in these plea agreements.
Yes.
Because we know that in other cases, if the judge sentences them to a term and then says, and credit for 364 days time served, and they didn't get it right, and they file their 300 motion, and they'll get the credit eventually. I mean, it would be nice to have it
Correct.
At the time. If we require anything more, I mean, I am sympathetic to this idea that there should be something that says I'm waiving all other credit for time already served, but if we require there to be, I know I should get 340 days, and I'm waiving that, and then we find out, no, it was really 380 days, then that will be a basis to set aside the plea. So to me, it would be, I'm asking you if you acknowledge that could create some other problems, that it would be better not to have a specific number, but to say, because the judge doesn't know, and the judge can ask, does anyone know the exact amount of time he would be entitled to? Is he waiving any other time? And maybe the issue is no. Our intent is that he shouldn't waive any other time, and they could put in the plea, he's getting this plus any other time served, which we think is this. So how would that work?
I agree with Your Honor that we don't need a specific number to say that, you're waiving 360 days for credit for time served versus 345 days.
Because you realize that
that could cause a lot of problems.
Can't you stipulate to the time? If you agree to it, that's what it is.
You can, but we do have problems. For example, in many cases, the defendant knows whether or not he's served time. He may not know the exact periods of time.
Or what qualifies, like the boot camp.
Or if he qualifies.
Yeah.
As in this case, Defendant Johnson served time in boot camp. I mean, he may not have had any idea that boot camp qualifies for credit for time served. What would be best would be, and I know at least in Miami-Dade County, while they don't have exact days of credit for time served, they do have, on the case history sheet, picked up on a probation violation or original sentence. Probation was reinstated with 30 days of credit for time served. There are certain notations that could generally reference periods of time that you were incarcerated. For example, when you're waiving any credit for time served that you've previously served upon your initial arrest, upon any other arrest, for probation violations, and those type of things, so that you look at the general periods of time.
Let me interject myself here, because I have some experience in this area. And you know, we were discussing these things as if we were in federal court, where the only case before the judge at that moment is the case. There's no one else in the courtroom. It's all a vacuum. The lawyer had plenty of time to talk to his lawyer about the case. The prosecutors had plenty of time to compute, and the clerk and all that. What is happening, particularly in Miami or Palm Beach or Broward or Tampa, Orlando, is that you have a courtroom with about 150 people in there. You got a jury box with about 20 prisoners. You got the public defenders who are whispering to their client while the court is going on with other cases. And this negotiations, this plea bargaining, is going on down to the last minute. And sometimes it calls for a waiver of this and waiver of that. There's no way at that moment to gather out this information as to how much credit he did 20 years ago when he was first placed on probation, and how much credit he got when he got out and got booked again. It's possible. So sometimes you have to come in and make an agreement that, look, all you're getting credit for is this from today on, period. And there's no time to gather out that previous information. So that's the reality of what goes on in these courtrooms. So the argument you're making seems to think that everybody's sitting at a table with a computer and this information can be gathered just like that. It's not possible.
I understand that, Your Honor, but at the least the court should question the defendant. Have you served any previous times? Have you served time in boot camp?
Well, why can't the court assume that the lawyer met with his client and had that information and told the client, look, you're waiving all this time. You're getting a great deal here today. You're going to waive all this time, and all you're getting credit for is this. Why can't the court assume that that conversation will occur between the lawyer and the client?
If the court were to ask, have you discussed with, the court has to ensure that there's an understanding, and maybe now's a good point to bring up in certain cases.
Question, did you discuss the matter of how many days you're waiving with your lawyer? Would that suffice?
A question similar to that, yes. Have you discussed this with your lawyer?
What if the lawyer's
aware
wrong?
that you've entitled to it? Excuse
me,
Your
What if the lawyer is wrong? I mean, right back to where we are again. The lawyer's wrong, then we got ineffective assistance of counsel, and we go back through this again. Well, I mean, there's got to be an answer to this somehow. I mean, you got to have a workable system.
Yes, I agree.
I'm sorry.
I'm not really certain. I think about, in some of these cases we have credit for time served checklists. They're trying to ameliorate the problem, but in effect they're not really changing anything, because even when you have a checklist, the court still in a plea type situation still has to inquire if the defendant's aware of the rights he's waiving, if he's read the agreement, if he knows any of those type of things under plea policies.
Isn't it the case that we are here dealing with the question of the relief that will be available on a 3800A?
Yes.
Which is a very specialized thing. Now, it seems, but why am I wrong to think that all these questions about what the defendant knew or didn't know and what his lawyer had told him and all those sorts of things are not things that can be determined in a 3800A unless it's shown on the record? And it seems to me that we're really talking about ineffective assistance here. There's a route to deal with that. It is not 3800A. There's another route. Or there's another route yet to deal with this is a motion to withdraw the plea. Now, there are time limits on that. But I don't understand why those are not the more appropriate venue or the places to deal with this sort of issue about what the defendant knew and what his attorney had told them and how he understood it. So if you could address that and then address the question of how it is fair in a 3800A and giving relief there to undo a plea agreement, because that's what we would be doing by ordering that credit be granted. Am I wrong?
Yes, Your Honor.
Tell me why I'm wrong on that second one.
I'll address them in reverse order.
Okay.
The first is that the default is that a defendant is entitled to all credit for time served unless that credit for time served is waived. So here we have...
What about the plea agreement?
Well, Because
the plea agreement trumps other things that are defaults all the time.
If there's a clear waiver in the plea agreement, and as this court found in McCoy versus State, it's the state's responsibility to ensure when entering into a plea agreement that the terms of the agreement are made part of the record.
There's the question of the voluntariness of the waiver. That's a separate issue. But there's clarity, the absolute, perfect clarity in the plea agreement about how much time there's going to be granted for jail credit. I mean, it's there. It says from this day to that day, or sometimes they might check the box, no credit.
Well,
that's going to be unambiguous, absolutely clear. What was agreed to?
Well, we don't know if that's what's agreed to, and that's what the problem herein lies. Now,
you may not. I understand. You may not know if the defendant understood what he was giving up when he agreed to that.
Yes.
I understand that. That's not necessarily going to be reflected there. But that's a different question than what was actually agreed to.
Yes. When you have this type of situation, when the court awards the credit for time served, it can be three different things that are happening. One, there could be a knowing voluntary waiver of all other periods of credit for time served. Two, it could be a misapplication of the law where the trial court thinks, okay, he's only entitled to credit from his last booking date. Or three, it could be a calculation error. And that's what we don't know in these situations.
Get back to I don't think you've answered my question about
yes, Your Honor.
How you address the concern that through giving this sort of relief, we're effectively undoing a plea agreement. The defendant is getting the benefit of the plea agreement that he wants, but some detriment here from the plea agreement, as in the limitation on the credit, is being lost to the state by the state. We're undoing this agreement that they had through this mechanism. Well, isn't that true?
And I would argue no, because it's the state's burden to show that there's a clear waiver of the credit for time served on the record.
But that answer really, I think, is a bit disingenuous here, because let's look at, I'm not sure if it's Johnson or Joyner.
Yes.
One of these cases, the defendant really could have gotten a life sentence, wasn't it? But he ended up getting a 4-year sentence.
Yes.
And got 100 and some days credit for time served. Now, if we really look at this, he got an absolutely wonderful bargain of 4 years as opposed to what he could have gotten, and he got some credit for time served. I mean, it seems to me that was a great bargain. But now, in hindsight, there's this, okay, wow, if I get some more credit for time served, I could be out. Because in essence, if we gave him the credit, I think it's the same defendant who was the boot camp defendant, isn't it?
Yes, that's correct.
And that boot camp was, what, 3 or 4 years?
No, it was not that long.
How long did he serve in boot camp?
It would have been 120 days.
Okay, and so how in the world can we even imagine that the state would have entered into this kind of agreement if he was going to also get all of this other credit for the boot time?
Well, simply,
it's troubling to me in these plea situations, because there's some quid pro quo going on. I'll settle for the 4 years if you settle for the whatever days that was, as opposed to all of these additional days, which would, in essence, he'd only have to serve a very short period of time.
Okay. Well, we don't know what type of quid pro quo was going on there. And first of all, we're not sure if there was a quid pro quo. Okay, we want you to serve exactly X amount of time. For example, in one of the earliest cases on this, in Epler versus judges of the 13th Judicial Circuit, there was a discussion between the court and the parties. The sentence was for 15 months with all credit for time served. And the attorney said, well, he wants to serve local time. And the court said, well, if you're going to serve local time, it's 1 year without any credit for time served. There was an actual discussion on the record regarding how much time should actually be served and how much credit for time served should be applied. And
but, honestly, now, I understand there are going to be all sorts of factual variations, and one circumstance or another will come up. But can you stand there and deny that by adopting the approach that you want for us to take, that there are going to be some circumstances when the state will lose a benefit that it bargained for as part of the plea agreement.
There may be some circumstances,
Isn't
but
the answer, though, on that? Let me just, because, you know, and I didn't really pick up on whether this is a 3800A issue, because in this case, the violation of probation hearing was in April of 2006, and the motion by Johnson was in 2007, so it was in the 2-year period. And I think there is the question on the remedy as to whether, when there is an allegation that the defendant did not know he was entitled to a different amount of time served and it wasn't part of the benefit of the bargain, that the answer is it goes to he gets to either withdraw the plea or claim ineffective assistance of counsel. I think that on that, I mean, I don't know if we're talking about something that happened 10 years later, but why isn't that really the appropriate way to go, which is to treat it as a motion to withdraw the plea based on a misapprehension, or it was a miscalculation, whatever it was, and then we get back to the square one. And I'm sorry, I didn't, because it just occurred to me that in this case, I wasn't prepared really to look at it and say it's an illegal sentence, that you're entitled to correct at any time, but that it's a claim to be able to withdraw the plea because it wasn't done knowingly. And what's wrong? I mean, why isn't that a more appropriate way to deal with these kinds of cases?
Well, in the Rule 3800A, of course, as you stated, doesn't allow for the evidentiary hearing. So in cases that are after the 2 years, then defendants, may be precluded from raising this type of issue if you state that it should be handled in a Rule 3850.
But we don't have to, in this case, though.
But we don't have that in this case. The second of all is that the default law is you are entitled to all credit for time served unless it's waived. And so we don't have an issue of what we're looking at here is, was there a waiver? So a defendant is entitled to it unless it's waived. And in that situation...
But if he didn't waive it, and he goes, I wouldn't have entered this plea
right.
if I had known I had another 120 days. I mean, because it strikes me, I was thinking about this benefit of the bargain. If the state knows or is capable of knowing how much time is served, it's really a kind of a plea agreement that bargains for an amount of time that's known. I mean, all they got to do is increase the sentence to 4 years and 120 days and then give them credit to get to the same point. So I don't really see this as one of these things where somehow the defendant's getting a windfall. I'm just suspecting that it's hard to figure out the amount of time. So they said, we're going to, just what Justice Labarga said, we're going to just give it from a set date, and that way we don't have any misunderstanding, and this is going to be your sentence. So I think it goes to the knowing and voluntary nature of the plea, which then the remedy is to withdraw the plea if it wasn't knowing and voluntary. And if the state goes, well, okay, we're going to give them, we'd only agree to the same sentence, but with additional, we're going to add on the time to the sentence, and then he can get more credit.
Okay. Well, first of all, prospectively, what we can do to prevent these situations from happening is to ensure that there is a knowing and voluntary waiver, to ensure that the trial court says during the plea colloquy to the defendant, you're agreeing to credit for time served from the date of your last arrest. Actually, you're entitled to all the credit for time served that you've served. And
in White, the fourth district case, the plea sheet that the defendant signed had in capital ball letters the statement, I am waiving all other credit for time already served.
Yes.
Would that suffice?
That would be a lot closer to getting where we would need to be. In this situation, if we're talking about what is the best for this court to suggest that trial courts should do, if you also look at the Reddick's opinion out of the Third District Court of Appeal, in that case, the justice...
You could just do, as Justice Parente suggested, this is the net time you'll serve, period. This is our bargain.
Yes, and then to say, and I'm waiving all other credit for time served. What the court in Reddick suggested in footnote 5 is it may be prudent for the trial court to consider including in the model colloquy a question to the defendant, that you're expressly accepting this plea, you're acknowledging it includes some or all other credit for time served that you're entitled to. And with that, and if there is a written credit for time served agreement, because not all cases include a written credit for time served agreement, to make sure on the written agreement it also states, as it did in the White case, in bold capital letters, I'm entitled to additional credit for time served. I am waiving all other credit for time served.
How does that resolve the boot camp issue?
For Mr. Johnson?
No, how does it resolve a case in which a poor slob stands before a judge and says, I'm giving it up, but yet doesn't know that he or she is entitled to additional time?
Well, then
that's what my concern is.
Then the colloquy should say, any additional time, and this may be time served in county jurors, it may be time served in other counties, it may be time served in boot camp. And then you also have to address the issue of prison credit, because there have been some cases where defendants waive jail credit and the defendant then gets to prison and the prison system says, oh, well, you've waived your prison credit also. So any type of colloquy would also have to address prison credit. I'm waiving my jail credit, but I'm not waiving my prison credit.
Have we made any progress? Justice Lewis asked about the JIS system. I hope I don't know if you're familiar with it, but it's a way to capture databases. There was a suggestion at one time that the Department of Corrections really is in the best position to keep on gathering and having this information. I mean, it just seems to me that all the state, the court system, the public defender, the individuals, that having an accurate accounting shouldn't be up to. I mean, the public defender may be in the worst position to have this information. The client doesn't necessarily keep track. So do we know of any system that exists around the state where they can get accurate information on the number of days? I mean, it's a straight computation.
I don't know, Your Honor. And one of the problems, at least in Miami-Dade, is every time that you re-enter a jail, you're given a new jail card. So if your sentence was in 2000 and you served, 6 months, and then you were on probation and you were fined for 5 years, when you come back and you re-enter the jail, you're given a new jail number and you have a new jail card. So often in these cases, yes, Your Honor.
What I just think is important, again, what I said before, the person who gets arrested today and goes to jail and gets out in 30 days on bond and then 6 months later comes in for a plea, the clerk can just look at the file and see how much time he served. Those are the easy cases.
Yes.
The difficult cases are the guy who's been on probation for 20 years, in and out during those 20 years. Different systems of keeping records throughout those 20 years. Maybe perhaps in and out of jail in different counties.
Yes.
It is impossible to get that information so we can tell this guy, listen, you altogether, you have served 375 days. You're waiving that, and we're starting credit from today only. It is impossible to do that in those type of cases. So what the state may do in those kind of cases is just throw the hands up in the air and say it's just easier to try it.
I'm not sure.
I'm not sure that the defense wants
that would be the state remedy. I mean, well, there are a couple of things. One, in an ideal world and prospectively, what can we ask for now? Perhaps this court can refer again to the Rules Committee, or before there was a Criminal Appeals Reform Committee, and the suggestion of what are we going to do about this credit for time served issue. The last time that happened was in 1999, and from the best I found out, nothing really happened with that. That's at the point the court looked at Rule 3700 and amended that to say, well, if the court knows, put jail credit in the sentence. Now, the second situation...
because that's a problem whether there's a plea agreement or not. I mean, I think we were concerned the vast majority of the 3.8 days are those that are not entered as a result of pleas. And again, just as Labarga said, it's the same problem if they're sentencing. They don't have an accurate number, and then in those cases, the person can come back and back again. So it behooves everybody to get this right.
That's correct. Now that's the ideal situation, and prospectively, if we can handle that. In the situation Justice Labarga speaks about, perhaps it would be sufficient if the trial court said to the defendant, listen, you've been on probation for 15 years. Obviously, during that time, you've been taken in and out of jails. You're entitled to all of that credit for time served. The state's offer today is that you actually serve 10 years of time with only 1 year of credit for time served. So any of those other periods of credit for time served, you're not going to be eligible for.
Without giving a specific number.
Right. Without giving a specific number, then that would satisfy the requirement that there being a knowing, intelligent, and voluntary waiver.
But it still doesn't answer what Justice Kennedy, I think, has brought up a good point, that at the most these claims can be brought in a 2-year period as a involuntary plea, not under 3800 as something that's cognizable at any time.
And I would strongly suggest and disagree with
you don't agree with that.
Now, what I may point this court to is because the decisions in these cases were stayed pending the decision in the case of Rivera versus State. And Rivera versus State was a little bit of a different case where the defendant would have been, everybody contemplated the defendant serving about 2.5 years. With the application of the credit, he would have been out in 10 or 11 months. So there was a question there, well, what do we do in that situation? Because their district actually coined it an absurd result. In those briefs, in that case, we more fully delved into the question of contract law and plea bargaining and what is the appropriate remedy. And under contract law, we raised an argument that under contract law, the state is not able to withdraw the plea. And I know that the attorney general may not be familiar with those cases. I did brief Rivera, so I'm a little familiar with it. But the court may want to go back and look at those arguments on the question of whether, this should be a 3800 or a 3850, and if necessary, I'd be happy to rebrief those issues.
Because you say that wasn't fully developed in this case.
No, in this case, it was not fully developed as we look at contract law. In Rivera, we looked at the restatement of contracts and who bears the burden of the risk.
But you see, what you said, though, in the end, is that a defendant is agreeing to a certain sentence. When they're agreeing, they're giving up something, everyone's giving up something. So it does seem to me that the answer is this general idea, listen, you've been in and out of on and off of probation. No one knows the exact number of days. You know there are days, but what you're agreeing to is a sentence that gives you this much time incarcerated. That's what you're getting.
Yes, as long as the defendant has knowledge that he served prior time, that he's entitled to...
Well, he knows he served prior time.
He served prior time.
But you don't know whether it qualifies. That goes back to the boot camp issue.
That's right, with the boot camp issue.
If Justice Parente's statement is correct, then all of these are fine, because they give you dates. But they don't answer the question, did you know that you were entitled to more than that? I mean, that's...
I think that's what's missing from the quality. Do you know that, you have prior time that's eligible? That would be the boot camp. That you are entitled to receive that time, and that you voluntarily relinquish that time.
And with our help, you have used more than your 30 minutes.
Thank you.
Thank you.
May it please the court, my name is Ha Dow, and I'm here on behalf of the state of Florida. And I would like to address the concerns that the court have raised today. First of all, Justice Lewis, in terms of whether a plea litany, where the trial court goes through these questions, satisfies the question of whether or not the defendant has sufficient knowledge to waive, I would submit to you that that just opens a Pandora box, because you're not talking about boot camp. You're also talking about prison time credit. You're also talking about time when a person is spending or is committed while his or her competency is being determined. So you got a wide variety of commitment time where credit can be argued but not sufficiently addressed at the time, either by counsel, by the court, or by the state attorney.
But shouldn't the obligation, let me go to this situation, because we're talking about boot camp. We don't know on this record whether the state was aware that it was one of these, that it was a misunderstanding, miscalculation, or a waiver, correct? Is that true? That we
That's
don't know
the
that?
argument being advanced,
and
yes.
That's what I think they make, the point being that when if the intent of something which says you're getting credit from a specific date is to convey to them, that defendant, who may be a very young defendant, that you are entitled to other credit, but it's too complicated right now, or it's too much time, or whatever, and this is the time you're going to serve, that seems to be what the problem is in the third district's approach, which is assuming that the defendant must know that he or she was waiving all this additional time.
But
here's, how do we remedy that?
But here's, the concept of waiver is very common. It's not really unique to the defendants in this case or people being imprisoned. You and I and the public out there waive our rights constantly.
But we always, of all the things that we've taken in this state and the court system, credit for time served, the idea that somebody shouldn't serve one day more than they're legally required to do.
And I submit to you that for those defendants who serve time awaiting disposition, goes to trial and get acquitted, they don't have any credit coming to them. Because credit can only be applied to the case that carries an incarcerated sentence. For those people who are found innocent, they don't have any redress for the time they spent. The statute was enacted to address the situation where people with limited financial means sit in jail longer than those who have. And so with that in mind, not all states offer credit for time served. And really, when you think about the context of violation of probation, the credit for time served gives the defendant leverage, a leverage that he would not have. In the first time sentencing, basically the judge will just announce the sentence and impose a certain amount of time. In a VOP, the person comes in and he's being presented with offers. The offer would be, I give you this much time net. And I would submit to you, as Justice Labarga has pointed to, the reality of trial is that the prosecutor would be remiss to enter into a deal not knowing what the net time is. The parties of the contract here have to be informed of the basis of their bargain.
The question really, though, becomes, how do we, and any court that's reviewing this, knows that this was a good bargain because the defendant knew and understood exactly what he or she was bargaining for.
Yes. And the state submits to you that the very form that Mr. Joyner and Mr. Johnson signed in this case, being aided by counsel, is evidence of that intent.
But it's not. But again, it's not, respectfully. If they had stayed with the form and not started writing handwritten notes on it, I agree with you. All, none, whatever it was. Yet they just started entering dates, and whether those are the correct dates or not, it doesn't assure you that if I'm standing before you as the judge that I know that I'm entitled to something more or not. You can't determine, you've just said it, you can't determine whether you waive something until you determine if you knew it.
Yes.
But just by seeing it on the paper just gives you 2 dates.
Correct. But the intent of the parties in entering into the bargain is that the defendant will give up something of an uncertain nature.
But the uncertainty usually is that if I go to trial, I'm going to get, I don't know what kind of sentence I'm going to get.
It could be a great exposure.
But here the uncertainty is just one that, because it's a little complicated, not for the trial judge, but maybe Department of Corrections or the state, well, we don't want to waste our time trying to figure out exactly what this person's entitled to. So it's a little different than the uncertainty of trial and then going to and that's why I'm kind of my question really is, from the state's point of view, when they enter these plea agreements where they give credit for time served from a date certain, are they doing it in order to because it's too hard for them to figure out what the time is served and they say this is just better, we'll all know what the time is? Or are they really saying, well, I want, how much time this guy have in boot camp? 120 days?
120 days.
I'm going to give this sentence of 4 years, but I'm going to have him waive the 120 days. Really, they could accomplish the same thing by saying, again,
correct.
He gets 4 years and 120 days, and he gets credit.
That is correct, Judge.
So
Justice.
that's, if you don't know the credit, you really don't know what the net is that you want, that is fair.
But it's subject to contract law. The parties may not know what the exact number is, but they are willing to forego that uncertainty.
What I'm asking is, this is not rocket science.
It's not rocket science.
Nightmare, but it's not rocket science. It's a calculation of days.
The practicality of it is that you would have to contact the jail, and each of the jail that the defendant has ever served time would have to get back to you about the number.
So why shouldn't that be an obligation that the state has, who was incarcerated this defendant, to figure it out, or say, listen, we know you've been in a lot of jails and you've been in a lot of different places, and so but we don't have the time to figure this all out. So we just want you to know that we're going to offer you this net deal.
Yes.
And there's probably other time you're entitled to, but just in the interest of your certainty and ours and preventing any future litigation.
Correct.
Let's just set it at the state.
Correct.
That's all you'd have to show.
That's correct.
That's what you did.
That's correct. Because whatever credit out there, trust me, the deal being offered is going to be very different. It's going to be inflated by the exact same number of credits. And as anybody who has done trial work know, the VOP calendar is quite monstrous. You know, you have these people come to the court with the idea that they may go to hearing, and then at the last minute they're talking about deals. And to me, the time pressure is there, admittedly, but the time pressure is actually a motivation for defendant to, for the defendant to look at his options. And I'm going back to the form because the form does give you a very good idea as to whether or not the defendant had some inkling of what he's giving up.
Well, that's what I have a difficult time with. If that were the case, then we wouldn't be here.
Well,
because you're always talking about waiver. Maybe the problem is we start with a fundamental principle that you're entitled to time served. Maybe the rule of law, and that's based on the case law of Florida. That's what I'm trying to read and follow. Yeah. Or maybe this court ought to say that in plea deals that rule doesn't apply, and it's only what's stated in the plea. I mean, maybe that's the answer to get rid of all this controversy. But we can play word games all day, but the case law, as you said, read it doesn't answer those questions.
No,
so if we don't talk about waiver, that's fine. Then we can get past this and
You're absolutely
let's
right,
forget
Justice
all this
Lewis.
stuff.
Yes, you're absolutely right, Justice Lewis. And really, at the end of the discussion, you realize there isn't any thorny issue that has to be resolved because whatever question you're asking, there's an answer. And with regards to what has been done since 1999, the logistic of it, perhaps it's not so much difficult, but it's gathering everybody, and pulling them together and being on the same page. You still have the problem with people inputting data on jail credits and then deposit in one place where people can draw from it. But the larger consideration
has there been something done since
not that I know of.
So what we're really saying is the court requested that something be done, that the state, with all these computer systems that the state hasn't done something that again, to me, it helps judges and litigants, not just in these plea cases, but in these other jail cases where they can ask for 300 relief at any time. That if we could get that done, we wouldn't have to worry about all of this other colloquy.
And I assure you, when you get that done, the plea being offered is going to be very different. Because as I indicated, the highlight of these cases is what the intent of the parties are.
Let me take you back to the subject I raised earlier, which is the significance of the fact that this is presented as a 3800A. Now, is it correct that the defendant, the movant, has the burden of establishing a clear entitlement to relief under 3800A?
On the face of the record and
on
nowhere
the face
else.
of the record. And isn't it also the case that what the defendant's lawyer told him about all the complexities of what he was entitled to or not entitled
That's
to
a 3850
is not
claim.
something that can be determined on the face of the record necessarily. Now, it could be that it would be laid out in some kind of colloquy.
Correct.
But it will not necessarily be. And you could have a defendant who knew exactly what he had and knew exactly what he was giving up,
and still makes the same
and
claim.
then would still be, under the theory that the public defender has here, getting relief
because the document doesn't say so,
because
or the record doesn't say so.
Because there's not some document that reflects that, and isn't that inconsistent? The approach of the public defender here inconsistent with the basic framework here we have under 3800A, which places the burden on the defendant.
Absolutely.
Well, what if you file the plea and the transcript of the hearing, and it shows on its face that the defendant did not know that they were entitled to more credit? Shows on the face of it. Becomes an illegal sentence.
And if that is the case being presented to the district court, they would have the power to send it back and to apply the credit.
We can get involved in trying to apply all these rules, and then you become rule-oriented rather than solving the problem.
Yes. Yes.
And so that's what we need to do here today, is to solve this problem. I think the state needs to be part of the answer. And I recognize, I mean, we started off by, I understand that it's just, next to impossible to determine in every case exactly what the credit is.
And
standing there in the courtroom, as Justice Labarge has done.
Yes, Justice Lewis, and I don't know that it is such an issue that would cause you to lie awake at night. With regards to what this court has done, for example, and I'll give you one example, Rule 3.260 requires a written waiver for jury trial. And that's a right that it's grounded in the Constitution. And in cases that came up in front of you for review, the defendant would say, I sign the waiver, but there's no plea colloquy, or there's no colloquy on the record that shows that I actually understood what I signed. And this very same court has said, so what? I have the writing.
Your suggestion is get rid of this waiver concept. I mean, it's you don't ever discuss it. It's gone. That paper speaks for itself.
On this form, isn't that an option under 3? No credit for time served. Check it. That's it. And you don't have this.
Justice Perry, what it does is that it's a standalone document, double-spaced, typewritten in very plain language. And we can play with words. And I submit to this court that it has never been about magic words. If the person read it and understand it, then the purpose has been achieved. But the first part of the form talks about the action of the defendant. I am hereby admitting to violation of probation. And then the transition phrase is written in first-person voice. I understand and agree that as part of this plea bargain, I will receive the following credit for time served. The words understand and agree comports with the statute mandate because the sentencing court is mandated to allow credit. So if the sentencing court gives, then the defendant receives.
So your argument really is, if you have this form and it has been signed by the defendant,
and
the
his
presumption
attorney
should be that the defendant knowingly and voluntarily waived any additional credit.
Absolutely.
Do you agree that
absolutely
have any of these cases, or because I didn't really look at the issue as before us, whether it's appropriate under 3800A versus 3.850? Is that something we should be?
The state has addressed that in its briefing, Your Honor. In fact, we moved to dismiss Mr. Joyner's case for mootness, and we filed a motion in January of this year to dismiss the case, in this court for the very reason that he has served out his time and it's moot and he cannot get relief when the sentence has been fully completed.
Well, but the mootness issue is different as to what is the proper type of relief that can be sought. And since let's assume we're addressing this,
sure.
Mr. Johnson filed his motion pro se. He filed it within 2 years, didn't he not?
Yeah, he filed the 3800A, and he doesn't allege that he did not know what he waived. He simply cited to the statute and said, I'm due all the credit, and all credit wasn't given to me. So that issue, as far as the state is concerned, was not raised below, hasn't been preserved with regard to actual knowledge.
And was that the kind of argument made in the district court also?
Correct, yes.
That it's because it's the burden of the defendant. You see, I thought the issue we were really looking at was whether there was a knowing and voluntary waiver, which really would be part of a 3850 issue about voluntariness of a plea.
But that's what the claim has been transformed into. Originally, Mr. Johnson and Mr. Joyner filed the 3800A saying the error is apparent on the face of the record
so it
and is correctable.
So they really did treat it as a 3850, didn't they?
Yes. And while treated as a 3800A, and the suggestion is that if you have claim outside of the record, you have to resort yourself to the 3850.
But wait, what's the impact on the plea agreement, though?
Under 3850?
Because if you go under a 3850, there'd be a different impact on the plea agreement than there is if you go in under 3800.
Absolutely. Yes, because under 3850, if you claim that...
Was there an evidentiary hearing in this
No, Your Honor, no. If you were to consider the same claim under 3850, an evidentiary hearing would be had. And the lawyer...
But I thought you said they transformed this into 3850.
I'm talking about the nature of the claim. They're now saying I didn't have actual knowledge of what I waived.
But the court didn't treat it as a 3850.
Not at all. Not at all.
I'm sorry.
Not at all. I'm sorry if I confused you.
I think that we go back to the issue, and I do think there's a separate question as to the appropriate the appropriate rule to bring it under. But going back to just the reasonableness of what's going on, is that, again, without it being explicit, we really don't know if there's miscalculation, misunderstanding, or waiver. And it just seems to me that since there are three choices, one is the number of days credit, that they actually can either also agree to all credit for time served. Now, if they do that and say, I want all credit for time served, does in the plea, is that with the understanding then that time served may be calculated after the entry of the sentence?
Yeah, at a later time.
Okay, so why isn't it this, again, whether we do this prospectively, when you have the option of blank days credit for time served, to say, and I understand that I may be entitled to additional time served since whatever time,
Absolutely.
And I am waiving that becomes explicit, and we really then don't have any question about what's there, but we know that it's something important that either the state should bring to the judge's attention or the defense or the lawyer, that yours is one of these cases that's a nightmare for us. So because we can't really know the exact date, you understand you're agreeing to this from a specific date.
Yes, and that has been suggested through case law within all the district courts. In fact, in the briefing, we mentioned the Hagan case out of First DCA, where the court held that there's a specific language indicating it's a specific date from this date to this day, and I would submit to you that these dates are significant because it triggers the person, the reader, the defendant, his attorney, to the event of the original arrest, the original sentencing date, the first violation arrest date, the first violation sentencing date. These are clues and cues.
I want to clarify one thing, because Justice Oriental mentioned that the reason for these type of agreements is not always that we can't figure out how much time you serve. I mean, sometimes, I think Justice Quince mentioned the case where someone may be charged with a first-degree felony, and they're dropping it down to a second-degree felony or a third-degree felony, and the deal is, okay, I'm going to drop it down from life to like a 15-year possible. I don't care what you served before. You're getting credit only from today's date in exchange for us dropping like 2 degrees down. So there are many reasons why it happens.
Yes.
It's not always because we can't figure it out.
That's right.
In most cases, we can figure it out. And that's...
You do recognize that Hagan, out of the first, is specifically in conflict with 2 other decisions from that court, both Velasquez and Gidget, which specifically hold that stipulation to a specific amount does not show the waiver.
And I submit to you that we don't see everything on in the 4 corners of the opinions, because facts on waiver vary.
Well,
they vary slightly, or they vary vastly.
That principle of law is in those 2 cases. It's in Reed out of the 2nd District, and it's in Davis out of the 5th. So that's what we have to resolve. That's why we're here, to resolve those things. So you cite Hagan without telling us, that you understand that it's in conflict with what the weight of authority there in the first is to the contrary.
And I don't think it's a matter that if you pick a specific number that is preferred over a range of dates. As I indicated to you, the range of days is useful to clue people into which period of time are you talking about. But it doesn't take care of boot camp, and it doesn't take care of modality treatment programs. So it's imperfect, and that's why these provisions are to be read together. So if you have the range of dates, and I'm reading it and I'm saying, okay, jogs my memory here. What dates are we talking about? The second box allows you to pick a number. And it's a ballpark number. It's not precise. And it could be just a little bit of the modality program, a little bit of boot camp, and then a bunch of days that I sat in county jail waiting. So I pick a number that's agreed upon. And that happens all the time in compromise and settlement, is that we may not know the extent of your claim, but you're saying the clock stops here. And then the third box says all credit for time served. Now you're talking about the universal credit for time served, and if I'm sitting there looking at the form, I would be asking the question just like taking a multiple choice question test. I have to read all the answers before I select the one that I think is right. So my memory is being jogged. I'm being clued into all these different options. I have options. I'm not presented just one choice. So when I'm looking at that box saying all credit for time served, I naturally, reasonably, as a person would say, what's out there?
We've talked a lot today about, when a defendant files these kinds of motions, they could be asking for a lot of different things. But once you have this form, the form similar to what we have here, isn't it incumbent upon the defendant then is it incumbent upon the defendant to demonstrate that it was a miscalculation, or that I didn't know that there were other credits out there and I subsequently found out, or whatever it is, the issue that he's supposed to be raising? Yeah. So in this case, let's take Johnson for an example. What was the exact argument that he made in his 3-800 motion about the credit for time served?
He relies solely on the statute and says, I am due all credit for time served, and it wasn't given to me. And the sentencing court, in response, attached part of the plea colloquy and the sign form. And the plea colloquy shows that prior to the court taking the case, defense counsel advised the court, we're still talking about the deal, Your Honor, we're not done. And that, in fact, Mr. Johnson has a counteroffer. So the sentencing judge said, well, go back, talk about it, and when you're done, you're going to come out, and then we're going to take your case.
I guess what disturbs me about these kinds of cases is, there are legitimate cases where the defendant may not have known that he was, as Justice Lewis was saying earlier, entitled to boot camp credit.
Yes.
Most of them know that when you're in jail or prison, you're entitled to credit, but maybe not boot camp.
Sure.
But then on the other hand, there are the possible cases where the defendant knows that all this credit that's available, agrees to this bargain, and then turns around
belatedly
and says,
file 3800.
Oh, gotcha. Yeah. There was some other credit. The statute says I'm entitled to all of this credit, and so now I want all of this credit. And I don't know how we weed out
we have two decisions.
Situations.
We have two decisions.
Just put a laundry list of the possible instances found in the statute.
And it wouldn't be exhausted because treatment programs, get created and you got
just listed. These are the possible areas.
That is one thing.
At least you would cut it down. I mean, you might.
You certainly, and the suggestions have always been that if you make it clearer, if you use the words waiver and entitlement and you boldface them or you underline them, then surely they can't come back and say, I don't know what I was doing. So all you have, and I don't know why we walk away from a signed document where the terms are simple, obvious, and unambiguous.
Well, I think the answer, frankly, is I'm leaning towards, and I guess I just want to look at it again, that I'm not sure it is appropriate as a 3800A if there is a plea agreement that specifies what the time served is. I think it probably would need to be brought as a 3850 motion to withdraw the plea. Then we would know if it's a situation, as Justice Quinn said,
whether it's genuine,
where it was a true bargain or lack of knowing that there was this other source of days and nobody talked about it.
Correct. Yes.
What would be wrong with requiring in a plea agreement in caps, capital letters, such as what the 4th District did in white, I am waiving all other credit for time already served, including any time served in treatment programs, boot camp, just that kind of thing. That would seem to me that would solve the problem, short of figuring out exactly how many days he served, or she has served, because we may not be able to figure that out.
Certainly. certainly. And that works as a disclosure that encompassing all the variety of commitment time that you may or may not be entitled to. And
that would tend to cut off the 3850s. Because
absolutely. Absolutely.
Kind of conclusively refuted in the record.
So since at least some of us think, yeah, that sounds great, that didn't happen here. I mean, so that's what we're back with, this conflict between the other district courts of appeal that have said these kinds of explicit statements do operate as a waiver versus ones that you have to read between the lines. So when we're all agreeing, I'm not sure it seems to me that if this is in the right procedural posture, that's the third district has said, no, that's not necessary. Right? Isn't that why we're here? It's because the third district doesn't think there does need to be that explicit statement.
We have always suggested that conflict doesn't exist because the facts of these cases vary slightly, and then also in the cases relied upon by the petitioner, Hinkle. And I can only think of Hinkle as one that is most telltale in terms of suggesting conflict. But Hinkle, the discussion on the merits, dicta. And if you look at the posture of these two cases, Mr. Johnson and Mr. Joyner have been released. So, they're
But the issue is still... The issue is still there.
But it doesn't evade...
We didn't deal with it in Rivera, and so it seems to me that it certainly is an issue capable of repetition, and so why...
It certainly is, yeah, it certainly is.
Shouldn't we deal with it?
And the court certainly could, wait for a case where it's not moot, or the court can take the occasion and decide what would be the appropriate remedy. However, with regards to the form, the state submits to you that in the evolution of case law, first we got the plea colloquy, that kind of sketchy, and then we have a notation in a judgment and sentence, and then we have a notation in a plea form, and now we finally come to a stand-alone document. And we certainly could improve on it, but don't invalidate it because.
But then judges then start fooling them with this one, because then it says credit for all time served, but then puts maybe a wrong date.
I realize it's the same form and it's filled out slightly differently.
And again, how much taxpayer money needs to be spent for you all to keep coming back up here? We need to get this thing out of the way, whatever the way is.
Yeah.
That's
right.
This is job assurance.
and certainly prophylactically, the court can devise a rule, to have the sentencing court incorporate that as a litany, as the public defender has suggested. The form could be improved.
But what Justice Lewis is suggesting, and I don't know where, we have to look back again, it just seems to me that we could get a lot of assistance, not in the context of an individual case, but from the Department of Corrections and the state, because the amount of time you spend defending these cases, if we can put it up front,
you can see the sheer numbers. Yes,
we would have it, and it would be fair to everybody, and not put this on the judge to have to be the ones who, ferret it out.
Call out the data. And I have seen cases where the plea colloquy is quite nice, and it eases everybody's mind when they read it because...
You must have read one of mine.
and although it seems that these cases give cause for concern, I would assure you that, the wheel of justice does turn.
Well, isn't that really, and I think that, Justice Labarga talks about, and we all appreciate how many defendants there are. We know, we look at the 4th District, the 3rd, that many judges do take that extra minute or two.
Absolutely.
And that's what we really want to encourage also, don't we?
Yeah, and the final note is as you have all seen through this exercise, is that, we hold, the statute certainly holds the sentencing court responsible for doing its job. And that the suggestions of this court is, in 1999 when this court commented on the same issue, is that the defendant knows best. The defendant may not know precisely, but he knows approximately how many days or how many places he'd been. And then it's the job of the public defender or the defense attorney to really be thoughtful about the discussion of plea. And so everybody takes responsibility, and maybe that's how we're going to solve the problem finally.
And with that, you have also exceeded your time. I want to thank both of you for your arguments here today.
Thank you. Thank you.
The court will now take its morning recess for 10 minutes.
Please rise.
now in recess.
Well done, Shannon.
The last case on the court's agenda for today is Dennis versus State. The parties may proceed.
Good morning. Suzanne Keffer on behalf of the appellant LeBrant Dennis. We're here after this court remanded for new proceedings to the circuit court, and we now have a summary denial with an order that I would argue is only marginally better than the first one that we were remanded on.
There was an evidentiary hearing before.
There was an evidentiary hearing before.
On the same allegations?
It's the same 3851 motion. The same arguments, essentially the same arguments were made at the case management conference. And now we have a summary denial.
I mean, I guess what I'm going to be asking the state is if it's the same motion, if we were able to determine on the face of the motion that it was not, we weren't entitled to relief, we wouldn't have sent it back. That's a helpful question to you, but
Absolutely, that would be my argument, Your Honor, and I think that this certainly, when you have an evidentiary hearing with one judge and it's sent back because for whatever reasons that order was inappropriate or due to the motion to recuse, and another judge on the same facts, on the same arguments, summarily denies, it emphasizes the arbitrariness of this process.
But summarily denied, was she able to review the evidentiary hearing and rely on what was in the evidentiary hearing?
The evidentiary hearing was not relied on because it was sent back for new proceedings. It was both Mr. Dennis's position and I believe the state's position that those proceedings should not be considered.
Well, you know, the rule is that you're entitled to an evidentiary hearing on any claims where there needs to be factual development, correct?
Correct.
And so tell us specifically what claims needed to have factual development in this case?
Absolutely. I think predominantly it would have been the ineffective assistance of counsel at the guilt phase, ineffective assistance of counsel at the penalty phase, and the Brady claim. They are all very fact-intensive claims, and certainly we argued below that the record did not...
And were these the claims you had an evidentiary hearing on before?
We had a full evidentiary hearing on definitely the ineffective assistance of counsel at the penalty phase. We had an evidentiary hearing on the Brady claim. And then there were portions of IAC guilt phase that we had received an evidentiary hearing on.
Because there seems to me that on the penalty phase, I don't know how we can determine this from the face of the record, and perhaps the Brady, but there does seem to be some of the guilt phase that do not need factual development, such as the failure to request a second attorney, and not really, that isn't a standalone claim, is it, that there should be a second attorney?
I'm not sure what you mean in terms of a standalone claim, but I think certainly with respect to the guilt phase claims, it's ineffective assistance of counsel. And so you would need to be able to present the trial attorney to determine whether he had a strategy for not doing certain things. Certainly there's several allegations of objections that he failed to preserve the record for appeal.
But I'm saying on the one where it says, and he was ineffective in failing to request a second attorney. If you've got to be able to point to deficiencies that because there weren't two attorneys, the defense attorney wasn't able to hire this expert or do that. You can't just say in a vacuum someone should have there's no right to two attorneys in the guilt phase.
Certainly, though, the ABA guidelines do recommend that there be a second chair attorney, and part of what the reasoning behind that is, and I think what's mentioned in the motion and where it definitely impacted Mr. Dennis, is with respect to the penalty phase.
Okay, so it would flow. So it really flows into the not just guilt phase, but it's not. You weren't saying he should have two attorneys for the guilt phase. Is that?
Well, I'm saying he should have had two attorneys from the get-go, because we know that you begin investigating the entire case from the beginning, and so of course that would have been important. I think also there are claims within the ineffective assistance of counsel guilt phase claim that he failed to do other investigations in terms of other suspects, and also failed to hire experts to refute the state's experts that were presented.
There may be subclaims that could be summarily denied. I guess your argument would be, listen, you kind of want to look at the whole picture of what the attorney's performance is, rather than try to say, well, this one isn't a good argument or that one. I mean, we might as well.
I think absolutely in terms of the guilt phase that there are numerous subclaims that have to be looked at as a whole. And certainly, I think that it's necessary to be able to call the trial attorney to determine whether his strategy for not doing, if there was a strategy for not doing certain things. And then again, whether that strategy was reasonable. And I don't think that the record refutes those allegations, conclusively refutes those allegations. I do want to point out, and as I stated, the circuit court's order is not much better than the first one that we were here on, which is particularly troubling given, again...
Please continue to speak into the mic.
I'm sorry. It's particularly troubling given what Justice Periente and Justice Quince has pointed out, that we had an evidentiary hearing and now we have a summary denial. Specifically with respect to the ineffective assistance of counsel at the penalty phase and the Brady claim.
Let me ask you this about the evidentiary hearing issues. If the trial judge had in fact used the transcript from the original, from the evidentiary hearing that did take place, would there be a problem with that?
I think there would be a problem with that because part of conducting an evidentiary hearing is for the court to sit and evaluate the credibility of the witnesses, and I think it's appropriate to do that on a cold record. I think that, what was proper to do would have been to hold another evidentiary hearing.
And you made that argument to the trial judge?
I absolutely made that argument at the case management conference to the circuit court, yes, I did. I pointed out both with respect to all of the factual claims, but again, focusing, because I think the order is really deficient with respect to penalty phase and Brady, that the record certainly does not refute that, one, trial counsel did absolutely no investigation into the penalty phase.
Now, is this is the case where just the mother and the grandmother testified at the penalty phase?
The mother and grandmothers testified at the penalty phase. And essentially their testimony, I would argue, was cumulative. They said that Mr. Dennis was a good son, that he was a good student, he went to college, and had a rap career.
And I noticed that a part of your argument on the penalty phase is really that there was no mental mitigation, but was he examined at all originally, either during the guilt phase or the penalty phase?
There is nothing in the record to suggest that he was.
And so did you present some mental mitigation at that evidentiary hearing that is no longer
the previous evidentiary hearing, we did present 2 psychological experts, and I certainly argued that at the case management conference in front of the circuit court this time around, too, that we had 2 psychological experts that were available to testify. They were available to testify to the effects of Mr. Dennis's environment growing up on his later adult life, on his development, specifically the violent community that he grew up in, Liberty City in Miami. We also said that we had an expert that could testify to his overall mental health and mental abilities and how that would affect his ability to adapt to prison. And that was set forth in our motion. It was argued at the case management conference, and the judge here, in her order, basically said that Mr. Dennis did not state what experts would be available. And I think that both the motion and the argument completely refute that, and that's just simply an inaccurate finding.
On the first go around, did the state sometimes does stipulate to evidentiary hearings? Was the evidentiary hearing originally stipulated to?
My recollection isn't entirely clear. I believe going into the first case management conference, the state was opposing an evidentiary hearing. However, once the judge granted a hearing, as we were proceeding through, granted a hearing on certain claims, and the state can correct this if I'm wrong. Like I said, I'm not quite sure. I think they said, well, if we're going to have an evidentiary hearing on this claim, we might as well have it on this claim and this claim. We won't. That's my recollection. Again, if I'm wrong, by all means, the state can correct me. But certainly that's my recollection. This time around, the state opposed an evidentiary hearing on every claim.
And what was, well, I assume their argument was that they can be determined from the record.
I believe the state's argument was either the motion was facially insufficient or was refuted by the record.
Well, was the claim, that's what you see, that's what I'm trying to find out, is this is whether there's a sort of a law of the case going on as far as this court's law of the case. If the allegations were facially insufficient, and I'm looking back at the original appeal of the post-conviction, that's something that should have been raised on the first go-around appeal. If this court found then that the pleadings were facially insufficient, they should have been given you would have then gone back and been given a chance to amend, so they could be facially sufficient. So I'm having trouble seeing how all of a sudden we're taking the same claims that were granted evidentiary hearing that we didn't affirm on alternative grounds the first time around. That is, that it was facially insufficient or that, there didn't need to be an evidentiary hearing, and now take the same motion and say, no, it's facially insufficient.
Well, that's not entirely the court didn't ultimately find that all of the claims were facially insufficient. In fact, she makes rulings with respect to the guilt phase claim, and she makes a ruling with respect to the Brady claim that doesn't say it's facially insufficient.
Just conclusively refuted by the record?
Correct. Or with respect to the Brady claim, she says under either version of the medical examiner's testimony, HAC is supported. But, I'm having trouble with this as well, and had trouble with this, from the time I got the circuit court's order. I'd maintain that from the beginning of this process, Mr. Dennis's motion is facially sufficient.
Is this really the same motion, or I thought there was amendments that were made to this motion when we sent it back?
We did amend the motion. We added 2 additional claims. There were not amendments made to the existing claims. So all of those facts are the same. There was a lethal injection claim made that we added, and a claim with respect to a report that came out.
So it wasn't like you reworded the motion. You just added an amendment to it that added these other claims.
That's correct.
So
none of the existing claims were changed. The motion is the motion that was filed November of 2003. It was the same motion. Correct. It's over 70 pages. Correct. With a lot of specific Yes, I believe the page limit is 75 pages, and there are very specific allegations. It was very fact-intensive. And, again, we both keep saying that it's problematic that one judge grants an evidentiary hearing on the same information and one judge doesn't. And then, again, if you look at the order, this order does not make specific references to the record. It's inaccurate in many places and uses, I was saying with respect to the Brady claim, it uses an inappropriate standard for review. There's not even any mention of Brady or what the court's understanding of what the Brady analysis should be. To me, the point is if this court thought the Brady claim was insufficient or conclusively refuted, we wouldn't have sent it back. We wouldn't. And maybe that we weren't clear on that, but that's what's frustrating to me. I agree. I feel like we, by maybe not being clearer, misled the judge into thinking that a summary denial was appropriate. I agree. The order that this court set forth after the last oral argument, and I would point out that I remember standing here and arguing at great length about the Brady claim and about materiality and whether it could be disposed of simply on materiality. And like you said, this court sent it back even after those arguments. The order that was sent back said that it was for a new post-conviction proceeding. So I can't say what the circuit court was thinking in that regard and what she felt her obligation was. I simply would, again, reiterate to this court that looking at the circuit court's order and looking at the motion, this motion was sufficiently pled to warrant an evidentiary hearing, specifically with respect to ineffective assistance of counsel at the guilt phase. There are numerous factual claims. Ineffective assistance at the penalty phase, especially where there was so little presented and so little in the record in comparison to what we have presented in the motion. And absolutely with respect to the Brady claim, because I don't believe that materiality can be resolved on this record, not without the testimony of the trial attorney in particular. With that, if the court has no further questions, I will reserve the rest of my time for rebuttal.
May it please the Court, Sandra Deggert, Assistant Attorney General, on behalf of the State. The State's position has always been that this motion was insufficiently pled and did not merit an evidentiary hearing.
I mean, it was always your position even in the first appeal.
Even in the first appeal, and there was an issue about recusal and an order entered after a recusal motion being void, and therefore this Court's order to redo the proceedings didn't say we found it sufficient and we're going to have a hearing.
But you know, and again, I know
if an order's void, the order's void. It doesn't matter.
I guess, though, that the problem is, I think her time needs to start. The problem is, and we haven't actually had this in a long time. We haven't had cases where there's been summary denials on very specific pleadings. So it was sort of surprising. When I saw this, I go, I remember this case. And then I go back to the other case. I go, my goodness, it was an evidentiary hearing. We sent it back because the judge had died and there were insufficient findings. If we thought that it was insufficiently pled, we could have made everyone's life easier and just said, it's dismissed because it's insufficiently pled.
And you have a Brady claim that says, well, the State sent a memo to its medical examiner asking her to testify in a specific manner where she doesn't testify in that specific manner. And you have victims who are beaten to death.
But I'm asking you
physical evidence.
Isn't it really a variation in the law of the case? You already said you raised the issue that it was legally and facially insufficient or conclusively refuted. And if we thought that it was, we wouldn't have sent it back. We would have affirmed on a different basis.
Well, and if you thought there needed to be evidentiary hearings on certain issues, you could have written that order, too. You just say go back and do the proceeding over again.
Well, there have been an evidentiary hearing, and we've now said we want a new proceeding. I would think that would have included a new evidentiary hearing.
But we have claims like counsel was ineffective for failing to investigate other suspects, where we have absolutely no allegation of what it was an investigation of other suspects would have revealed.
Ms. Jagger, we understand that often in these ineffective assistance of counsel claims, there are numerous claims. And we are not saying that every one of those you have to have an evidentiary hearing on. But there are some claims here where there seems to be a question of fact that is not a part of the record. Those are the kinds of claims that we have said you need an evidentiary hearing on.
But all of the guilt phase claims are either claims where counsel was ineffective for failing to make a non-meritorious objection. The only things they had an evidentiary hearing on the first time was that counsel was ineffective for failing to hire crime scene experts. At the evidentiary hearing, they actually presented no crime scene experts whatsoever, and in the motion, they don't even allege what presenting a crime scene expert would do.
What about the guilt phase? I mean, the penalty phase.
The penalty phase,
seems to me
you have
that the allegation is that there was not a thorough investigation of this case. There were only a couple of witnesses presented at the penalty phase, and certainly there was no mental health mitigation presented at the penalty phase. And so how does the record refute that there was insufficient investigation?
It refutes that their allegations about what would have been discovered would have prejudiced the defendant. Their allegations were that you would get non-statutory mitigation, that he was psychologically affected by growing up in a bad neighborhood and would do well in prison. You have a trial court who, on the record, without any psychological testimony, found the extreme mental or emotional disturbance. So on their allegations, they're negating their own mitigation. And then you have a case with HAC, CCP, during the course of a felony and prior violent felony. So you're going to present non-statutory mitigation, rebut your own statutory mitigation, and it's not going to outweigh.
It sounds to me like in all the cases where we've had evidentiary hearings on, we should have just thrown them out and not had evidentiary hearing, because many of them have CCP and HAC, and so when those are present, no matter how much non-statutory mitigating evidence, it's not going to make a difference. We just make that determination up front, no evidentiary hearing.
It depends on what the allegations are. If the allegations are this defendant had a horribly abusive childhood and he had bipolar disorder and he was a drug addict, then sure, you may need an evidentiary hearing. That's not the allegations in this case. There's no allegations about anything like that.
Because, well,
the motion needs to be
to me,
pled.
because you don't have the same kind of allegations of what the mental or even family mitigation is going to be, does not negate the fact that a defendant ought to be able to show that there was, in fact, mental and family mitigation that the trial counsel did not investigate and did not present.
If he alleges sufficient facts to show that it's going to outweigh the aggravation, where he alleges facts that aren't going to show that it's going to outweigh, that's actually going to negate his own mitigation that he got. He got statutory mitigation, and their allegations was they were going to present an expert to say, no, he just has non-statutory.
I'm concerned then, because what it sounds like to me you're saying is that the defendant has got to make his case.
The defendant has to plead
Excuse me. The defendant, yes, has to make allegations in his 3.851 motion. But you are saying to me, and what I'm hearing, is that the defendant has to prove his case in his 3.851 motion.
No, what I'm saying is the defendant has to plead sufficient facts to show an entitlement to relief. And where his pleading shows itself, he would not be entitled to relief if he proved the facts he's alleging. Accepting his allegations is true, he's not going to be entitled to relief.
Silent and failure to hire a crime scene expert.
Yes, and there was no allegation whatsoever of what a crime scene expert would do. And as far as the failure to object to the alleged comment on the right to remain silent, what had happened was the defendant had showed up at the police station on the day of the crime when the police weren't ready to speak to him and had given them an alibi and done things, been fingerprinted, and the defense during the cross-examination of the lead detectives, attempted to portray this as him being cooperative. And he was wonderfully cooperative, and despite this fact, the police zeroed in on him anyway. And all the state did was point out that that wasn't true. They wanted to speak to him more later when they were actually ready, and he wasn't actually being cooperative. Where a defendant lies about what happened, the state is allowed to bring up the fact that he invoked his constitutional rights, and that's not true.
What about
the Brady claim was a trial preparation memo to the medical examiner saying, for the penalty phase, saying, you're being brought in for HAC, we need you to talk about the number of blows, we need you to talk about the victim's suffering. It suggests she used the term languish and die, which she doesn't use. So if we were coaching her, we weren't very successful. And you have a case where these victims were beaten to death, and they have defensive wounds. And the male victim actually got up and walked around, and we have his handprints all along the walls, coming up on the door as he's trying to get out. He's still alive when his roommate shows up, and he turns his face when his roommate calls his name. The female victim was still alive when the medical examiners came in, and she attempted to move in response to them. Where you have a beating death, where the victims weren't immediately killed and rendered unconscious, it's HAC. So you can impeach the medical examiner from here to the cows come home, it's still HAC. It doesn't affect anything.
How about there were issues with regard to other suspects, and I know one was Ray Lewis, but there were others. How was that pled, and what is your position with regard to whether there's enough given to the judge for the entitlement of a hearing, and what is that information?
And the pleading, that claim was summarily denied the first time. They were, in fact, told it was insufficiently pled and that the judge would allow them to amend it, and they never did. The pleading says counsel should have investigated other suspects. Ms. Lumpkins has a diary. At the beginning of the diary, it has a page that says menstrual and has initials on certain days. There's then a back part of this diary where there's a day-to-day planner. And on one day where the initial R appears, there's a notation that Ms. Lumpkins went and saw Mr. Lewis's football practice. So from that, we're now going to assume that Ms. Lumpkins was sleeping with these people. And then we should have investigated these people. And, oh, by the way, we tried to investigate Mr. Lewis, and he refused to speak to us. And that was it. We never said what an investigation of these people would do at all.
Or any other one other than that individual?
It was Ray Lewis, based on the R, and someone named Pete. That was the entire allegation of who this person even was. And that's why that claim has always been summarily denied. It was facially insufficient. We have claims that counsel was ineffective for failing to object to testimony that this court ruled on direct appeal was not, to the extent there were objections, the admission of the evidence is harmless, and to the extent that there weren't objections, it was a fundamental error, which under this court's Chandler case means she can't prove prejudice. We had claims that counsel was ineffective for failing to object to admissible evidence that's clearly admissible evidence. Things like someone saying, I looked at a slash in a tire and it looked more like a knife mark than it did like a nail puncture. A witness is allowed to testify and describe what they saw. A claim that counsel was ineffective for failing to object to the introduction of the fact they did a rape kit on Ms. Lumpkins, where the defense was that the police didn't investigate other motives. So this is direct rebuttal to the defense. It's admissible evidence. And so we have a motion that was insufficiently pled with regard to the guilt phase. You have a Brady claim that even assuming you can show that we didn't give you this trial prep memo is not going to make a difference, because even if you impeach the second medical examiner, it's still going to be HAC based on the physical evidence. And you have an allegation about mitigation that you're going to present through an investigation where your own allegations show that you wouldn't end up getting relief. And therefore, it's the state's position that this was properly summarily denied. The court has no further questions. The state respectfully requests you affirm.
Any rebuttal?
Just briefly, I do want to point out a couple things that what is required under Rule 3.851 is that we make a detailed factual allegation of the claims. That has been done here. And as Justice Quince pointed out, the point of an evidentiary hearing is for Mr. Dennis to prove those claims. It doesn't have to be proven in the motion. Otherwise, nobody would need an evidentiary hearing.
Well, but the point is, if the facts that you allege, however, don't add up to a basis for relief, then it can be denied without a hearing. It's not a question because you're absolutely right to the extent that you mean that the court has to accept all the allegations as being true. But if the court, having done that, says, well, so what? It wouldn't have made any difference, or it either wasn't deficient performance, or that there would be no prejudice, or whatever, then it can be denied without a hearing, right?
Absolutely, but I'd like to point out that's not what the circuit court here did. With respect to the penalty phase, the circuit court said there was no deficient performance because trial counsel did present the evidence that we're now alleging. That's not true. We've presented numerous facts.
Can I ask a question about the penalty phase? It does seem as though this is a little different than some that you have presented to us and that we've seen in these contexts. Is an allegation that a defendant has lived or has grown up in, been reared in Miami, and that's a violent area, sufficient just in and of itself without more to go into how the impact on the individual to require a hearing?
Absolutely. I think
share with
especially,
me. I mean, that's a conclusion.
Yeah.
Help me understand what your view is on that. I'm from Miami, and I don't know that just saying that makes that true. I mean,
well, I don't think it's a matter of just coming from Miami. This is a particular area of Miami, Liberty City. We were able to present previously and would be able to do so again, an expert which really talked about the extent of the violence in that area.
All right. So
and
I
what
accept
that would mean to a child's development, specifically than Mr. Dennis's development
and what
in that
is
area. It impacted his relationships. He had a very unstable home life. Went on to explain that it certainly, witnessing that kind of violence then impacts how Mr. Dennis responds in certain situations and his own behavior. And that certainly has been alleged. I think also this court has granted penalty phase relief.
Did the trial judge in this case find that he was under severe mental stress at the time? I mean, in the original sentencing?
The trial court called it emotional distress, not extreme emotional disturbance, based on the fact that the state conceded that that mitigator could be possible given the state's own theory. But when the circuit court then
did... statutory, correct? That's what we're speaking of?
Yes.
Okay,
although
so that was
the circuit
found.
Court called it emotional distress,
Okay.
yes.
But that was found in the severe
It was given little
distress.
to no weight.
Okay.
That's what the state is neglecting to say, is that the circuit court gave it little to no weight. Had trial counsel done his job, had trial counsel done any investigation whatsoever, all of this information about the violent community, how that impacted the defendant, how it in fact impacted his adult life and his behavior and his relationships, had...
Is he the defendant that witnessed a murder or something, somebody being killed?
We detailed several violent incidents that, yes, Mr. Dennis witnessed. One of them was somebody being shot, I believe at point-blank range in the head right in front of him when he was younger. And there was a couple other violent incidents that Mr. Dennis witnessed. We also alleged that, the McDuffie riots had occurred in this area, and certainly that was very violent. And for a child to be in that community and be in that area at the time, certainly it would have impacted Mr. Dennis. So all of these very specific facts were alleged. And I want to point out that this court has granted penalty phase relief on non-statutory mitigation. Most recently in Dwayne Parker v. State. In that case, the court said that just on the basis of non-statutory mitigation, he was entitled to a new penalty phase. So whether or not there's statutory mitigators or not would not preclude Mr. Dennis from getting an evidentiary hearing. The last thing I want to say, and I'm just about done, it's on the Brady claim. And the state has stood up here and argued to the court that this was just simply witness contact. However, it's disingenuous. The state stood up here at the last oral argument and in response to Justice Quince's questions said that this memo never should have been written. And when pushed on that, whether it should have been turned over to defense counsel, Justice Quince let the answer go, and Ms. Jagger didn't answer. The issue here is materiality, and that can't be proven on the record. There needs to be an evidentiary hearing to hear from trial counsel, to hear what trial counsel would have done, and then it can be argued how the jury would have weighed the HAC. It's not simply whether it existed or not, but how the jury would have weighed the HAC, knowing that Dr. Rao was impeached, and also now given the mitigation that's now available. And so I'd ask this court to remand for an evidentiary hearing on the fact-based claims.
Thank you both for your arguments here today. The court will now be in recess.
Please rise.
You are watching the Florida Channel, a public service of the Florida Legislature, WFSU TV, and Florida State University.